Welcome to today's deep dive. We're looking at a landmark 2026 Supreme Court case, Kanchana Rai v. Geeta Sharma. And if you think this is just some dry legal text, think again. This is a totally compelling, human-centered family drama that could impact anyone from senior citizens to law students.
Oh, absolutely.
Imagine this scenario. A wealthy patriarch, Dr. Mahendra Prasad, passes away, and he leaves behind a will that completely disinherits two of his living sons, Ranjit and Rajiv.
Yeah, and the tragedy really compounds there because shortly after Dr. Prasad's death, his disinherited son Ranjit also passes away.
Wow.
Which leaves behind his wife Geeta.
Okay, let's unpack this. Ranjit's newly widowed wife, Geeta, is now facing, serious financial difficulty. She decides to ask her late father-in-law's estate for financial maintenance. But here is the core conflict. Her husband was technically still alive at the exact moment the father-in-law passed away.
Right, yes, and the executor of the estate basically tried to use a stopwatch to get out of paying her.
Wait, so they were trying to argue, technically you weren't a widow at the exact second he died, so you get nothing. That is cold.
Very cold. And to understand how the court handled this, we need to look at the Hindu Adoptions and Maintenance Act of 1956.
Right, the Hama.
Exactly. The executor really relied on confusing two parts of the law. Section 19 is about a living father-in-law's duty to a widowed daughter-in-law.
Ah, living father-in-law.
Right. But the court stepped in and said, no, Section 22 is what actually applies here.
So how does Section 22 change things?
Well, think of Section 22 like a mortgage attached to a house.
Okay.
Whoever inherits the house automatically inherits the debt attached to it. Under this section, anyone who inherits an estate has a strict, unavoidable obligation to financially support the deceased person's dependents out of those funds.
Regardless of the exact timeline.
Exactly, regardless of the timeline.
Right, but the executor is still arguing she wasn't a dependent yet.
Right, right. And what's fascinating here is how the Supreme Court dismantled that argument. They applied what's known as the literal rule of statutory interpretation.
Meaning they just read it exactly as is.
Yes, which just means they looked at the exact words on the page, nothing more, nothing less. They went straight to Section 21, which defines who qualifies as a dependent.
And what does it actually say?
It deliberately uses the phrase, any widow of his son. Notice what word is missing there.
Oh, here's where it gets really interesting. It doesn't specify if the son was already dead when the father died. It doesn't say predeceased.
You caught it. The legislature left out the word predeceased. The court pointed out that judges cannot just fix sloppy estate planning by adding words to a clear statute.
Wow.
Because the text explicitly just says any widow of his son, the exact timeline of the husband's death is legally irrelevant.
But if the text is that literal, does the court just ignore the human element? I mean, it almost sounds like she won on a lucky technicality.
Not at all. And that is where the Constitution comes in. The court realized it makes absolutely no sense to treat a widow differently just because her husband died a day after his father instead of the day before.
That makes sense.
Doing so would create a completely arbitrary class system, which directly violates Article 14, the right to equality.
Ah, because you're denying her a financial anchor based on random, fortuitous timing?
Yeah.
Which would likely push her into poverty.
Which brings in Article 21, the right to life with dignity. The court even reached back to ancient texts like the Manu Smriti to hammer this home.
The Manu Smriti.
Yes. They noted that supporting vulnerable family members isn't just some modern legal hurdle. It's a sacred obligation tied directly to the family wealth itself. The estate has a pious duty to ensure the family isn't forsaken.
So what does this all mean? If we step back from the courtroom for a second, what's the takeaway for someone drafting their will today?
The real insight here isn't just about paying maintenance. It's that courts will not fix your sloppy estate planning by adding words to the law. Inheriting family wealth automatically comes with the legal duty to care for the family's vulnerable dependents.
You can't just take the money and run.
Exactly. You simply cannot take the money and ignore those who need robust financial protections.
And for the legal professionals tuning into this deep dive, this case serves as a brilliant example of harmonizing strict statutory text with broader constitutional morality.
It really does.
It shows exactly how to prevent unjust outcomes by reading the law exactly as it was written while ensuring it aligns with fundamental rights.
It proves that the law isn't just rigid text on a page. It's an evolving tool designed to pierce through technical loopholes, protect the vulnerable, and ultimately uphold human dignity.
I love that. Let's leave you with this final thought to ponder on your own. If inheriting family wealth carries this bound-by-law duty to support vulnerable dependents, regardless of the exact timeline of a tragedy, How might this fundamentally reshape the way people approach their modern estate planning today?